Hi everyone, the Gazette has a new name. It's now called Nostalgia USA, and each month it's getting better. A real entertainment experience. And within each issue there will be special pricing on selected oldtimeradiodvd.com collections, only available to our subscribers of the Nostalgia USA. Take advantage today by subscribing at oldtimeradiodvd.com. Nostalgia USA, special pricing. What a combination. Go to oldtimeradiodvd.com today. You'll be glad you did.
Let's now join our featured presentation.
The Rise and Fall of the Confederate Government by Jefferson Davis, Part 2, Chapter 4. The Constitution not adopted by one people in the aggregate. A great fallacy exposed. Mistake of Judge Story. Colonial relations. The United Colonies of New England. Other associations. Independence of communities traced from Germany to Great Britain, and from Great Britain to America. Mr. Everett's provincial people. Origin and continuance of the title United States. No such political community as the people of the United States. The historical retrospect of the last three chapters and the extracts from the records of a generation now departed have been presented as necessary to a right understanding of the nature and principles of the Compact of 1787, on which depended the questions at issue in the secession of 1861 and the contest that ensued between the States. We have seen that the United Colonies, when they declared their independence, formed a league or alliance with one another as United States. This title antedated the adoption of the Articles of Confederation. It was assumed immediately after the Declaration of Independence, and was continued under the Articles of Confederation, the first of which declared that the style of this Confederacy shall be the United States of America, and this style was retained, without question, in the formation of the present Constitution. The name was not adopted as antithetical to, or distinctive from, Confederate, as some seem to have imagined. If it has any significance now, it must have had the same under the Articles of Confederation, or even before they were adopted. It has been fully shown that the States, which thus became and continued to be united, whatever form their union assumed, acted and continued to act as distinct and sovereign political communities. The monstrous fiction that they acted as one people in their aggregate capacity has not an atom of fact to serve as a basis. To go back to the very beginning, the British colonies never constituted one people. Judge Story, in his commentaries on the Constitution, seemed to imply the contrary, though he shrinks from a direct assertion of it, and clouds the subject by a confusion of terms. He says, "Now it is apparent that none of the colonies before the Revolution were, in the most large and general sense, independent and sovereign communities. They were all originally settled under and subjected to the British Crown." And then he proceeds to show that they were, in their colonial condition, not sovereign, a proposition which nobody disputed. As colonies, they had no claim and made no pretension to sovereignty. They were subject to the British Crown, unless, like the Plymouth colony, a law unto themselves, but they were independent of each other, the only point which has any bearing upon their subsequent relations. There was no other bond between them than that of their common allegiance to the government of the mother country. As an illustration of this may be cited the historical fact that when John Stark, of Bennington memory, was before the Revolution engaged in a hunting expedition in the Indian country, he was captured by the savages and brought to Albany in the colony of New York for a ransom. But, inasmuch as he belonged to New Hampshire, the government of New York took no action for his release. There was not even enough community of feeling to induce individual citizens to provide money for the purpose. There were, however, local and partial confederacies among the New England colonies, long before the Declaration of Independence. As early as the year 1643, a Congress had been organized of delegates from Massachusetts, Plymouth, New Haven, and Connecticut, under the style of the United Colonies of New England. The objects of this confederacy, according to Mr. Bancroft, were protection against the encroachments of the Dutch and French, security against the tribes of savages, the liberties of the gospel in purity and in peace. The general affairs of the company were entrusted to commissions, 2 from each colony, but the same historian tells us that to each its respective local jurisdiction was carefully reserved, and he refers to this as evidence that the germ principle of state rights was even then in existence. Thus remarkable for unmixed simplicity, he proceeds, was the form of the first confederated government in America. There was no president, except as a moderator of its meetings, and the larger state, Massachusetts, superior to all the rest in territory, wealth, and population, had no greater number of votes than New Haven. But the commissioners were in reality little more than a deliberative body. They possessed no executive power, and, while they could decree a war and a levy of troops, it remained for the States to carry their votes into effect. This confederacy continued in existence for nearly 50 years. Between that period and the year 1774, when the First Continental Congress met in Philadelphia, several other temporary and provisional associations of colonies had been formed, and the people had been taught the advantages of union for a common purpose, but they had never abandoned or compromised the great principle of community independence. That form of self-government, generated in the German forests before the days of the Caesars, had given to that rude people a self-reliance and patriotism which first checked the flight of Roman eagles, which elsewhere had been the emblem of their dominion over the known world. This principle, the great preserver of all communal freedom and of mutual harmony, was transplanted by the Saxons into England, and there sustained those personal rights which, after the fall of the Heptarchy, were almost obliterated by the encroachments of Norman despotism, but, having the strength and perpetuity of truth and right, were reasserted by the male hands of the barons at Runnymede for their own benefit and that of their posterity. Englishmen, the early settlers, brought this idea to the wilds of America, and it found expression in many forms among the infant colonies. Mr. Edward Everett, in his 4th of July address, delivered in New York in 1861, following the lead of Judge Story, and with even less caution, boldly declares that, before their independence of England was asserted, they, the colonies, constituted a provincial people. To sustain this position, utterly contrary to all history as it is, he is unable to adduce any valid American authority, but relies almost exclusively upon loose expressions employed in debate in the British Parliament about the period of the American Revolution, such as "that people," "that loyal and respectable people," "this enlightened and spirited people," etc., etc. The speakers who made use of this colloquial phraseology concerning the inhabitants of a distant continent, in the freedom of extemporaneous debate, were not framing their ideas with the exactitude of a didactic treatise, and could little have foreseen the extraordinary use to be made of their expressions nearly a century afterward, in sustaining a theory contradictory to history as well as to common sense. It is as if the familiar expressions often employed in our own time, such as "the people of Africa" or "the people of South America," should be cited by some ingenious theorist of a future generation, as evidence that the subjects of the Khedive and those of the King of Dahomey were but one people, or that the Peruvians and the Patagonians belonged to the same political community. Mr. Everett, it is true, quotes 2 expressions of the Continental Congress to sustain his remarkable proposition that the colonies were a people. One of these is found in a letter addressed by the Congress to General Gage in October, 1774, remonstrating against the erection of fortifications in Boston, in which they say, "We entreat your Excellency to consider what a tendency this conduct must have to irritate and force a free people, hitherto well disposed to peaceable measures, into hostilities." From this expression, Mr. Everett argues that the Congress considered themselves the representatives of "a people." But, by reference to the proceedings of the Congress, he might readily have ascertained that the letter to General Gage was written in behalf of the town of Boston and province of Massachusetts Bay, the people of which were considered by all America as suffering in the common cause for their noble and spirited opposition to oppressive acts of Parliament. The avowed object was to entreat His Excellency, from the assurance we have of the peaceable disposition of the inhabitants of the town of Boston and of the province of Massachusetts Bay, to discontinue his fortifications. These were the people referred to by the Congress, and the children of the Pilgrims who occupied at that period the town of Boston and province of Massachusetts Bay would have been not a little astonished to be reckoned as one people, in any other respect than that of the common cause, with the Roman Catholics of Maryland, the Episcopalians of Virginia, the Quakers of Pennsylvania, or the Baptists of Rhode Island. The other citation of Mr. Everett is from the first sentence of the Declaration of Independence, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, etc., etc. This, he says, characterizes the good people of the colonies as one people. Plainly, it does no such thing. The misconception is so palpable as scarcely to admit of serious answer. The Declaration of Independence opens with a general proposition. One people is equivalent to saying any people. The use of the correlatives one and another was the simple and natural way of stating this general proposition. One people applies, and was obviously intended to apply, to all cases of the same category, to that of New Hampshire, or Delaware, or South Carolina, or any other people existing or to exist, and whether acting separately or in concert. It applies to any case and all cases of dissolution of political bands, as well as to the case of the British colonies. It does not, either directly or by implication, assert their unification, and has no bearing whatever upon the question. When the colonies united in sending representatives to a Congress in Philadelphia, there was no purpose, no suggestion of a purpose, to merge their separate individuality in one consolidated mass. No such idea existed, or, with their known opinions, could have existed. They did not assume to become a united colony or province, but styled themselves united colonies, colonies united for purposes of mutual counsel and defense, as the New England colonies had been united more than 100 years before. It was as United States, not as a state or united people, that these colonies, still distinct and politically independent of each other, asserted and achieved their independence of the mother country. As United States, they adopted the Articles of Confederation, in which the separate sovereignty, freedom, and independence of each was distinctly asserted. They were United States when Great Britain acknowledged the absolute freedom and independence of each, distinctly and separately recognized by name. France and Spain were parties to the same treaty, and the French and Spanish idioms still express and perpetuate, more exactly than the English, the true idea intended to be embodied in the title, Les États-Unis, or Los Estados Unidos, the States United. It was, without any change of title, still as United States, without any sacrifice of individuality, without any compromise of sovereignty, that the same parties entered into a new and amended compact with one another under the present Constitution. Larger and more varied powers were conferred upon the common government for the purpose of ensuring a more perfect union, not for that of destroying or impairing the integrity of the contracting members. The point which now specially concerns the argument is the historical fact that, in all these changes of circumstances and of government, there has never been one single instance of action by the people of the United States in the aggregate, or as one body. Before the era of independence, whatever was done by the people of the colonies was done by the people of each colony separately and independently of each other, although in union by their delegates for certain specified purposes. Since the assertion of their independence, the people of the United States have never acted otherwise than as the people of each state, severally and separately. The Articles of Confederation were established and ratified by the several states, either through conventions of their people or through the state legislatures. The Constitution which superseded those articles was framed, as we have seen, by delegates chosen and empowered by the several States, and was ratified by conventions of the people of the same States, all acting in entire independence of one another. This ratification alone gave it force and validity. Without the approval and ratification of the people of the States, it would have been, as Mr. Madison expressed it, of no more consequence than the paper on which it was written. It was never submitted to the people of the United States in the aggregate, or as a people. Indeed, no such political community as the people of the United States in the aggregate exists at this day or ever did exist. Senators in Congress confessedly represent the States as equal units. The House of Representatives is not a body of representatives of the people of the United States, as often erroneously asserted, but the Constitution, in the second section of its first article, expressly declares that it shall be composed of members chosen by the people of the several States. Nor is it true that the President and Vice President are elected, as it is sometimes vaguely stated, by vote of the whole people of the Union. Their election is even more unlike what such a vote would be than that of the Representatives, who in numbers at least represent the strength of their respective States. In the election of President and Vice President, the Constitution, Article 2, prescribes that each State shall appoint, in such manner as the legislature thereof may direct, a number of electors, for the purpose of choosing a President and Vice President. The number of these electors is based partly upon the equal sovereignty, partly upon the unequal population of the respective States. It is, then, absolutely true that there has never been any such thing as a vote of the people of the United States in the aggregate. No such people is recognized by the Constitution, and no such political community has ever existed. It is equally true that no officer or department of the general government formed by the Constitution derives authority from a majority of the whole people of the United States, or has ever been chosen by such majority. As little as any other is the United States government a government of a majority of the mass. Part II, Chapter 5. The Preamble to the Constitution, We the People. The preamble to the Constitution proposed by the Convention of 1787 is in these words: "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." The phraseology of this preamble has been generally regarded as the stronghold of the advocates of consolidation. It has been interpreted as meaning that we, the people of the United States, as a collective body, or as a nation, in our aggregate capacity, had ordained and established the Constitution over the States. This interpretation constituted, in the beginning, the most serious difficulty in the way of the ratification of the Constitution. It was probably this to which that sturdy patriot Samuel Adams of Massachusetts alluded when he wrote to Richard Henry Lee, "I stumble at the threshold." Patrick Henry, in the Virginia Convention on the third day of the session, and in the very opening of the debate, attacked it vehemently. He said, speaking of the system of government set forth in the proposed Constitution, that this is a consolidated government is demonstrably clear, and the danger of such a government is, to my mind, very striking. I have the highest veneration for those gentlemen, its authors, but, sir, give me leave to demand, what right had they to say, "We the people"? My political curiosity, exclusive of my anxious solicitude for the public welfare, leads me to ask, who authorized them to speak the language of "we the people" instead of "we the States"? States are the characteristics in the soul of a confederation. If the States be not the agents of this compact, it must be one great consolidated national government of the people of all the States. Again, on the next day, with reference to the same subject, he said, "When I asked that question, I thought the meaning of my interrogation was obvious. The fate of this question and of America may depend on this. Have they said, 'We the States'? Have they made a proposal of a compact between States? If they had, this would be a confederation. It is otherwise most clearly a consolidated government. The question turns, sir, on that poor little thing, the expression, "we the people," instead of "the States of America." The same difficulty arose in other minds and in other conventions. The scruples of Mr. Adams were removed by the explanations of others, and by the assurance of the adoption of the amendments thought necessary, especially of that declaratory safeguard afterward embodied in the Tenth Amendment, to be referred to hereafter. Mr. Henry's objection was thus answered by Mr. Madison: "Who are the parties to it [the Constitution]? The people, but not the people as composing one great body, but the people as composing 13 sovereignties. Were it, as the gentleman Mr. Henry asserts, a consolidated government, the assent of a majority of the people would be sufficient for its establishment, and, as a majority have adopted it already, the remaining States would be bound by the act of the majority, even if they unanimously reprobated it. Were it such a government as is suggested, it would be now binding on the people of this State, without having had the privilege of deliberating upon it. But, sir, no State is bound by it, as it is, without its own consent. Should all the States adopt it, it will be then a government established by the 13 States of America, not through the intervention of legislatures, but by the people at large. In this particular respect, the distinction between the existing and proposed governments is very material. The existing system has been derived from the dependent, derivative authority of the legislatures of the States, whereas this is derived from the superior power of the people. It must be remembered that this was spoken by one of the leading members of the Convention which formed the Constitution, within a few months after that instrument was drawn up. Mr. Madison's hearers could readily appreciate his clear answer to the objection made. The people intended were those of the respective States, the only organized communities of people exercising sovereign powers of government, and the idea intended was the ratification and establishment of the Constitution by direct act of the people in their conventions, instead of by act of their legislatures, as in the adoption of the Articles of Confederation. The explanation seems to have been as satisfactory as it was simple and intelligible. Mr. Henry, although he fought to the last against the ratification of the Constitution, did not again bring forward this objection, for the reason, no doubt, that it had been fully answered. Indeed, we hear no more of the interpretation which suggested it from that period for nearly half a century, when it was revived and has since been employed to sustain that theory of a great consolidated national government which Mr. Madison so distinctly repudiated. But we have access to sources of information not then available, which make the intent and meaning of the Constitution still plainer. When Mr. Henry made his objection and Mr. Madison answered it, the Journal of the Philadelphia Convention had not been published. That body had sat with closed doors, and among its rules had been the following: that no copy be taken of any entry on the journal during the sitting of the House without the leave of the House; that members only be permitted to inspect the journal; that nothing spoken in the House be printed or otherwise published or communicated without leave. We can understand, by reference to these rules, how Mr. Madison should have felt precluded from making allusion to anything that had occurred during the proceedings of the Convention. But the secrecy then covering these proceedings has long since been removed. The manuscript journal, which was entrusted to the keeping of General Washington, the President of the Convention, was deposited by him 9 years afterward among the archives of the State Department. It has since been published, and we can trace for ourselves the origin and ascertain the exact significance of that expression, "we the people," on which Patrick Henry thought the fate of America might depend, and which has been so grossly perverted in later years from its true intent. The original language of the preamble, reported to the Convention by a committee of 5 appointed to prepare the Constitution, as we find it in the proceedings of August 6, 1787, was as follows: "We, the people of the States of New Hampshire, Massachusetts, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia, do ordain, declare, and establish the following Constitution for the government of ourselves and our posterity." There can be no question here what was meant. It was the people of the States, designated by name, that were to ordain, declare, and establish the compact of union for themselves and their posterity. There is no ambiguity nor uncertainty in the language, nor was there any difference in the convention as to the use of it. The preamble, as perfected, was submitted to vote on the next day, and, as the Journal informs us, it passed unanimously in the affirmative. There was no subsequent change of opinion on the subject. The reason for the modification afterward made in the language is obvious. It was found that unanimous ratification of all the States could not be expected, and it was determined, as we have already seen, that the consent of 9 States should suffice for the establishment of the new compact between the States so ratifying the same. Any 9 would be sufficient to put the proposed government in operation as to them, thus leaving the remainder of the 13 to pursue such course as might be to each preferable. When this conclusion was reached, it became manifestly impracticable to designate beforehand the consenting States by name. Hence, in the final revision, the specific enumeration of the 13 States was omitted, and the equivalent phrase "people of the United States" inserted in its place, plainly meaning the people of such States as should agree to unite on the terms proposed. The imposing fabric of political delusion which has been erected on the basis of this simple transaction disappears before the light of historical record. Could the authors of the Constitution have foreseen the perversion to be made of their obvious meaning, it might have been prevented by an easy periphrasis, such as "We, the people of the United States, hereby united," or something to the same effect. The word "people" in 1787, as in 1880, was, as it is, a collective noun, employed indiscriminately, either as a unit in such expressions as "this people," "a free people," etc., or in a distributive sense as applied to the citizens or inhabitants of one State or country, or a number of States or countries. When the Convention of the Colony of Virginia in 1774 instructed their delegates to the Congress that was to meet in Philadelphia to obtain a redress of those grievances, without which the people of America can neither be safe, free, nor happy, it was certainly not intended to convey the idea that the people of the American continent, or even of the British colonies in America, constituted one political community. Nor did Edmund Burke have any such meaning when he said in his celebrated speech in Parliament in 1775, "The people of the colonies are descendants of Englishmen." We need to go no further than to the familiar language of King James's translation of the Bible for multiplied illustrations of this indiscriminate use of the term, both in its collective and distributive senses. For example, King Solomon prays at the dedication of the temple, "that thine eyes may be open unto the supplication of thy people Israel, to hearken unto them in all that they call for unto thee. For thou didst separate them from among all the people of the earth to be thine inheritance." 1 Kings chapter 8, verses 52 and 53. Here we have both the singular and plural senses of the same word, one people, Israel, and all the people of the earth, in 2 consecutive sentences. In "the people of the earth," the word "people" is used precisely as it is in the expression "the people of the United States" in the preamble to the Constitution, and has exactly the same force and effect. If in the latter case it implies that the people of Massachusetts and those of Virginia were mere fractional parts of one political community, it must in the former imply a like unity among the Philistines, the Egyptians, the Assyrians, the Babylonians, and the Persians, and all other people of the earth, except the Israelites. Scores of examples of the same sort might be cited if it were necessary. In the Declaration of Independence we find precisely analogous instances of the employment of the singular form for both singular and plural senses: "one people," "a free people," in the former, and "the good people of these colonies" in the latter. Judge Story, in the excess of his zeal in behalf of a theory of consolidation, bases upon this last expression the conclusion that the assertion of independence was the act of the whole people of the United Colonies, as a unit, overlooking or suppressing the fact that in the very same sentence the colonies declare themselves free and independent states, not a free and independent state, repeating the words "independent states" 3 times. If, however, the Declaration of Independence constituted one whole people of the colonies, then that geographical section of it, formerly known as the colony of Maryland, was in a state of revolt or rebellion against the others, as well as against Great Britain, from 1778 to 1781, during which period Maryland refused to ratify or be bound by the Articles of Confederation, which, according to this theory, was binding upon her, as a majority of the whole people had adopted it. A fortiori, North Carolina and Rhode Island were in a state of rebellion in 1789-90, while they declined to ratify and recognize the Constitution adopted by the other 11 fractions of this united people. Yet no hint of any such pretension, of any claim of authority over them by the majority, of any assertion of the supremacy of the Union is to be found in any of the records of that period. It might have been unnecessary to bestow so much time and attention in exposing the absurdity of the deductions from a theory so false, but for the fact that it has been specious enough to secure the countenance of men of such distinction as Webster, Story, and Everett, and that it has been made the plea to justify a bloody war against the principle of State sovereignty and independence, which was regarded by the fathers of the Union as the cornerstone of the structure and the basis of the hope for its perpetuity. Part II, Chapter 6. The Preamble to the Constitution, subject continued. Growth of the Federal Government and accretions of power. Revival of old errors. Mistakes and misstatements. Webster, Story, and Everett. Who ordained and established the Constitution? In the progressive growth of the government of the United States in power, splendor, patronage, and consideration abroad, men have been led to exalt the place of the government above that of the States which created it. Those who would understand the true principles of the Constitution can not afford to lose sight of the essential plurality of idea invariably implied in the term United States, wherever it is used in that instrument. No such unit of the United States is ever mentioned therein. We read that no title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept, etc. The President shall not receive within that period any other emolument from the United States or any of them. The laws of the United States and treaties made or which shall be made under their authority, etc. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies. The federal character of the Union is expressed by this very phraseology, which recognizes the distinct integrity of its members, not as fractional parts of one great unit, but as component units of an association. So clear was this to contemporaries that it needed only to be pointed out to satisfy their scruples. We have seen how effectual was the answer of Mr. Madison to the objections raised by Patrick Henry. Mr. Tench Coxe of Pennsylvania, one of the ablest political writers of his generation, in answering a similar objection, said, "If the Federal Convention had meant to exclude the idea of union, that is, of several and separate sovereignties joining in a confederacy, they would have said, 'We, the people of America,' for union necessarily involves the idea of component states, which complete consolidation excludes." More than 40 years afterward, when the gradual accretions to the power, prestige, and influence of the central government had grown to such extent as to begin to hide from view the purposes for which it was founded, those very objections, which in the beginning had been answered, abandoned, and thrown aside, were brought to light again, and presented to the country as expositions of the true meaning of the Constitution. Mr. Webster, one of the first to revive some of those early misconceptions so long ago refuted as to be almost forgotten, and to breathe into them such renewed vitality as his commanding genius could impart, in the course of his well-known debate in the Senate with Mr. Hayne in 1830, said, "It cannot be shown that the Constitution is a compact between State governments. The Constitution itself, in the very front, refutes that proposition. It declares that it is ordained and established by the people of the United States. So far from saying that it is established by the governments of the several States, it does not even say that it is established by the people of the several States, but it pronounces that it is established by the people of the United States in the aggregate. Judge Story, about the same time, began to advance the same theory, but more guardedly and with less rashness of statement. It was not until 30 years after that it attained its full development in the enunciations of sectionists rather than statesmen. Two such may suffice as specimens. Mr. Everett, in his address delivered on the 4th of July, 1861, and already referred to, says of the Constitution: "That instrument does not purport to be a compact, but a constitution of government." It appears in its first sentence not to have been entered into by the States, but to have been ordained and established by the people of the United States for themselves and their posterity. The States are not named in it. Nearly all the characteristic power of sovereignty are expressly granted to the general government and expressly prohibited to the States. Mr. Everett afterward repeats the assertion that the States are not named in it. But a yet more extraordinary statement of the one people theory is found in a letter addressed to the London Times in the same year, 1861, on the causes of the Civil War, by Mr. John Lothrop Motley, afterward Minister to the Court of St. James. In this letter, Mr. Motley says of the Constitution of the United States: "It was not a compact. Who ever heard of a compact to which there were no parties? Or who ever heard of a compact made by a single party with himself? Yet the name of no State is mentioned in the whole document. The States themselves are only mentioned to receive commands or prohibitions, and the people of the United States is the single party by whom alone the instrument is executed. The Constitution was not drawn up by the States, it was not promulgated in the name of the States, it was not ratified by the States. The States never acceded to it, and possessed no power to secede from it. It was ordained and established over the States by a power superior to the States, by the people of the whole land in their aggregate capacity," etc. It would be very hard to condense a more amazing amount of audacious and reckless falsehood in the same space. In all Mr. Motley's array of bold assertions, there is not one single truth, unless it be perhaps that the Constitution was not drawn up by the States. Yet it was drawn up by their delegates, and it is of such material as this, derived from writers whose reputation gives a semblance of authenticity to their statements, that history is constructed and transmitted. One of the most remarkable, though perhaps the least important of these misstatements, is that which is also twice repeated by Mr. Everett, that the name of no State is mentioned in the whole document, or, as he puts it, the States are not named in it. Very little careful examination would have sufficed to find, in the second section of the very first article of the Constitution, the names of every one of the 13 then existent States distinctly mentioned, with the number of representatives to which each would be entitled, in case of acceding to the Constitution, until a census of their population could be taken. The mention there made of the States by name is of no special significance. It has no bearing upon any question of principle, and the denial of it is purely gratuitous illustration of the recklessness of those from whom it proceeds, and the low estimate put on the intelligence of those addressed. It serves, however, to show how much credence is to be given to their authority as interpreters and expounders. The reason why the names of the ratifying States were not mentioned has already been given. It was simply because it was not known which States would ratify. But, as regards mention of the several States, each State, any State, particular States, and the like, the Constitution is full of it. I am informed by one who has taken the pains to examine carefully that document with reference to this very point, that without including any mention of the United States, or of foreign States, and excluding also the amendments, the Constitution, in its original draft, makes mention of the States as States no less than 70 times, and of these 70 times only 3 times in the way of prohibition of the exercise of power. In fact, it is full of statehood. Leave out all mention of the States. I make no verbal point or quibble, but mean the States in their separate, several, distinct capacity, and what would remain would be of less account than the play of the Prince of Denmark with the part of Hamlet omitted. But, leaving out of consideration for the moment all minor questions, the vital and essential point of inquiry now is, by what authority the Constitution was ordained and established. Mr. Webster said it was done by the people of the United States in the aggregate. Mr. Everett repeats substantially the same thing, and Mr. Motley, taking a step further, says that it was ordained and established by a power superior to the States, by the people of the whole land in their aggregate capacity. The advocates of this mischievous dogma assume the existence of an unauthorized, undefined power of a whole people, or people of the whole land, operating through the agency of the Philadelphia Convention to impose its decrees upon the States. They forget, in the first place, that this convention was composed of delegates, not of any one people, but of distinct States, and in the second place, that their action had no force or validity whatever. In the words of Mr. Madison, that it was of no more consequence than the paper on which it was written, until approved and ratified by a sufficient number of States. The meaning of the preamble, "We, the people of the United States, do ordain and establish this Constitution," is ascertained, fixed, and defined by the final article. The ratification of the conventions of 9 States shall be sufficient for the establishment of this Constitution between the States so ratifying the same. If it was already established, what need was there of further establishment? It was not ordained or established at all until ratified by the requisite number of States. The announcement in the preamble, of course, had no reference to that expected ratification, without which the preamble would have been as void as the body of the instrument. The assertion that it was not ratified by the States is so plainly and positively contrary to the well-known fact, so inconsistent with the language of the Constitution itself, that it is hard to imagine what was intended by it, unless it was to take advantage of the presumed ignorance of the subject among the readers of an English journal to impose upon them a preposterous fiction. It was State ratification alone, the ratification of the people of each State independently of all other people, that gave force, vitality, and validity to the Constitution. Judge Story, referring to the fact that the voters assembled in the several States, asks where else they could have assembled. A pertinent question on our theory, but the idea he evidently intended to convey was that the voting of the people by States was a mere matter of geographical necessity, or local convenience, just as the people of a State vote by counties, the people of a county by towns, beats, or precincts, and the people of a city by wards. It is hardly necessary to say that in all organized republican communities majorities govern. When we speak of the will of the people of a community, we mean the will of a majority, which, when constitutionally expressed, is binding on any minority of the same community. If, then, we can conceive and admit for a moment the possibility that, when the Constitution was under consideration, the people of the United States were politically one people, a collective unit, 2 deductions are clearly inevitable. In the first place, each geographical division of this great community would have been entitled to vote according to its relative population, and, in the second, the expressed will of the legal majority would have been binding upon the whole. A denial of the first proposition would be a denial of common justice and equal rights. A denial of the second would be to destroy all government and establish mere anarchy. Now, neither of these principles was practiced or proposed or even imagined in the case of the action of the people of the United States, if they were one political community, upon the proposed Constitution. On the contrary, 70,000 people in the State of Delaware had precisely the same weight, one vote, in its ratification as 700,000 and more in Virginia, or 400,000 in Pennsylvania. Would not this have been an intolerable grievance and wrong? Would no protest have been uttered against it, if these had been fractional parts of one community of people? Again, while the will of the consenting majority within any State was binding on the opposing minority in the same, no majority or majorities of States or people had any control whatever upon the people of another State. The Constitution was established not over the States, as asserted by Motley, but between the States, and only between the States, so ratifying the same. Little Rhode Island, with her 70,000 inhabitants, was not a mere fractional part of the people of the whole land during the period for which she held aloof, but was as free, independent, and unmolested as any sovereign power, notwithstanding the majority of more than 3 millions of the whole people on the other side of the question. Before the ratification of the Constitution, when there was some excuse for an imperfect understanding or misconception of the terms proposed, Mr. Madison thus answered in advance the objections made on the ground of this misconception and demonstrated its fallacy. He wrote that it will be a federal and not a national act, as these terms are understood by objectors, the act of the people as forming so many independent states, not as forming one aggregate nation, is obvious from this single consideration, that it is to result neither from the decision of a majority of the people of the Union nor from that of a majority of the States. It must result from the unanimous assent of the several States that are parties to it, differing no otherwise from their ordinary assent than in its being expressed, not by the legislative authority, but by that of the people themselves. Were the people regarded in this transaction as forming one nation, the will of the majority of the whole people of the United States would bind the minority, in the same manner as the majority in each State must bind the minority, and the will of the majority must be determined either by a comparison of the individual votes or by considering the will of the majority of the States as evidence of the will of a majority of the people of the United States. Neither of these have been adopted. Each State, in ratifying the Constitution, is considered as a sovereign body, independent of all others, and only to be bound by its own voluntary act. It is a tedious task to have to expose the misstatements, both of fact and of principle, which have occupied so much attention, but it is rendered necessary by the extent to which they have been imposed upon the acceptance of the public through reckless assertion and confident and incessant repetition. I remember, says Mr. Webster, to have heard Chief Justice Marshall ask counsel, who was insisting upon the authority of an act of legislation, if he thought an act of legislation could create or destroy a fact or change the truth of history. Would it alter the fact, said he, if a legislature should solemnly enact that Mr. Hume never wrote the history of England? A legislature may alter the law, continues Mr. Webster, but no power can reverse a fact. Hence, if the Convention of 1787 had expressly declared that the Constitution was to be ordained by the people of the United States in the aggregate, or the people of America as one nation, this would not have destroyed the fact that it was ratified by each State for itself, and that each State was bound only by its own voluntary act. Bledsoe. But the Convention, as we have seen, said no such thing. No such community as the people of the United States in the aggregate is known to it, or ever acted on it. It was ordained, established, and ratified by the people of the several States, and no theories or assertions of a latter generation can change or conceal this fixed fact as it stands revealed in the light of contemporaneous records. End of chapter 6. Recording by Sean Stipsky, Kingman, Arizona.